Good morning. Thank you. Please be seated. This is the time set for oral argument in our case entitled Duenas. I hope I pronounced that correctly.
As close as I can get, Judge.
Maria Stella Duenas versus Life Care Centers of America. Our cause number 1CA CV130477. As counsel almost surely know, we have reviewed the briefs, the facts, the issues, and we've conferenced already and talked about the case some, and we're ready for your argument. And we certainly will, I suspect, have some questions, and we'll look for guidance from each side. And 20 minutes, if Mr. Boehm, on behalf of appellants, wishes to reserve some time for rebuttal, you know how to do that, and we leave it up to you to watch the clock. State your name when you arrive, please.
Good morning, Your Honors, and may it please the Court. My name is Scott Boehm. I'm appellate counsel for plaintiff, joined at counsel table by Fred Rispoli, who's trial counsel. We're here today, as you know, on a personal injury case for alleged elder abuse that resulted in the death of Maria Aspicia. We alleged in the trial court two separate claims, one on behalf of the estate under APSA, and a separate wrongful death claim on behalf of the beneficiaries to my client and her brother. The issues presented here today, and I believe we raised 6 of them, all pertain to which of the claims, if any, need to be arbitrated pursuant to the March and July arbitration agreements. Now, as you know, we've raised, multiple defenses. Some apply to some claims, some apply to all claims, and it gets a little with all the intersecting and cross-referencing. It's what applies to what is almost as maybe even more confusing than the legal arguments themselves.
Can I ask you an overarching question?
Yes.
Okay. Let's assume for a moment that we set unconscionability aside. Okay. Let's assume that the agreements that were signed are valid agreements, and I understand 2 were signed, 2 were not. Right?
That's correct.
Okay. Why shouldn't the arbitrator decide whether the scope of the arbitration clause in the first agreement is sufficient to encompass the entire course of care and therefore all of the claims?
Because I think that's a legal issue that's presented to the court.
But the agreement delegates the question of scope to the arbitrator. So it seems to me that we have a clash between the court's duty to decide whether an agreement exists and the arbitrator's right to decide whether the scope of an agreement that does exist includes the full course of care.
Well, I think if the court were ultimately to decide that only the first 2 agreements were enforceable, and obviously we disagree with that, I think in that situation, the arbitrator could decide which claims, which conduct could be applicable under the first 2 agreements. But if this court decides, and that's the issue we're presenting to you, that the conduct that occurred after the discharge on July 28th, which was the end of the second stay, if you will, if the court decides that nothing that occurred after that is covered by any agreement, that no agreement exists as to those, then we don't even get to the arbitrator on that.
I'm following you, and I agree with you, but let's take it one step further. Let's assume that it played out that way, and the court decided that no agreement existed for stays 3 and 4. Wouldn't there still be a question in the face of the court's determination as to whether agreement number 1 had such a broad scope that an arbitrator could disagree with our conclusion?
No, because I think that would be usurping the court's role. Because if that question were deferred to the arbitrator, and if the arbitrator were to decide, based on Lord knows what, that the subsequent conduct and the death were covered by the first 2 agreements, then it would, in effect, be deciding that there is a contract covering those claims.
Well, but the contract, and I just pulled the first one in the record. I'm assuming they're
They're identical.
They're
Yeah,
identical.
that's
Thank
what
you.
I've got.
Thanks
too,
for
'cause
that. Okay.
I have a cleaner copy of that one.
At the top of the second page, in the first paragraph, the resident agrees with the facility that any dispute, and then go down to number 2, including the scope of the arbitration clause, or number 3, the arbitrability of any claim or dispute shall be resolved by the arbitrator. It seems to me that if the first 2 arbitration agreements are not void for another reason, whether events that happened after the second stay are covered within the stay and care clause of the arbitration agreements. Put differently, whether the arbitrability of claims arising from care after the second by the agreement is for the arbitrator to decide. Now, the defendants don't argue that. The defendants seem quite happy to have the court decide that issue, which is another issue. But what's the answer?
Yeah, I think the problem with that, Judge, is that and of course we're looking at this under the scope of these particular facts. But if and as my client's affidavit explained, her mom had been in the nursing home many times, and had she not died, would have been there many more times for short stays like this. And if and even though I disagree that these are kind of close together, but if there was an arbitration, and let's take an example that doesn't exist. Let's say in 2005 they signed an arbitration agreement, and she was there 30 times until 2012 and then died. Do we go all the way back to the original arbitration agreement to decide the scope of everything that happened every time after that? And I agree with you that under the language here, the arbitrator decides the scope and what's covered by the arbitration clause under this agreement. But I think the court has the initial obligation to decide what are the parameters of the application of this agreement to the claims alleged. Of course, we have to prove those down the road. But
it isn't. It sounds like existence of an agreement and scope of an agreement are 2 vehicles for deciding the exact same question. And the problem is the court decides existence, the arbitrator decides scope. Can we really say that they're different exercises?
I can't disagree with you on that, Judge. I've kind of had this discussion with lawyers under trying to figure out what is, even before this the new statute was adopted, what does the court get to decide, and what does the arbitrator get to decide? And I think my answer, and I keep coming back, I hate to sound like a broken record on this, but I think the issue presented to the court today, and it is a court issue as opposed to an arbitration issue, is whether the claims that we've alleged, the subsequent, the November, December, and death claims, are covered by the agreement. Because it's similar, I guess, and maybe this analogy doesn't work very well, but arbitration agreements are very common in nursing home cases. I've been up here a million times with Judge Swan on these, but they're also very common in.
How'd you do it?
Well, it depends what side of the table I'm on, I guess.
With Judge Swan.
I don't remember, to be honest with you. They're very common in automobile cases too. If you buy a car in March here, for example, and I sign an arbitration agreement for that car, and then I go back in November and buy my daughter a car, and I don't sign the arbitration agreement. Well, I don't think it would be up to the arbitrator in the March car that I bought myself to decide whether my daughter's is covered by that 6 months later, and it probably doesn't fit perfectly because there's questions of whether the conduct continues
it's not
forward.
The same.
And but it's a similar situation that they're trying to bootstrap. I guess they're not doing it. The court is wondering if we need to bootstrap back the idea of whether the claims that we've alleged, or some of the claims that we've alleged, have to go back to the initial contract. And I guess I would hope, I don't have anything other than the seat of my pants on this, that the court would come to the conclusion that it's the court's job in the initial instance to determine if the conduct alleged fits within the agreement. And then once you get back to that, if it does, then the scope of it and what types of remedies apply. Go ahead, Judge.
It's kind of surprising, but would you agree that the issue of the effect of serial transactions under arbitration agreements is an issue of first impression in Arizona?
In this court, yeah, we've had some other stuff, but I don't remember ever having this be an issue on appeal. Especially because, I mean, we've had them where they were all signed. Because it happens, I mean, this happens all the time where people go in for a short experience. But
Some institutions are better about getting their documents
yeah,
signed.
and they some of them read better than others, and fortunately, we're getting to the point now in Arizona. We've been litigating these arbitration agreements now for 15 years, since Resga was one of the first ones, and defendants are learning what they have to put in them to withstand scrutiny and blah blah blah. But this is, I don't know that I've been involved with one before where at some point the plaintiff stopped signing them. Said, they tend to all be, well, they were signed. And of course, we'd have this issue that you're talking about wouldn't be here if all four of these were signed. We'd still have our reasonable expectations and blah, blah, blah. All those arguments that we have against attacking the March and June ones. And that those would still apply, and we think that we have to go back under Matthews and Resga for a hearing on those. And I'll get to one other point on that in a minute. But this is, I think, the first time where a plaintiff, either on advice of counsel or, this was submitted to her probably just before her mom's death. So she probably decided, well, I'm not signing these anymore. So yeah, it is the first one before you. One thing I do want to point out before I forget about it, and it pertains to this, is, and the way these come down, and you mentioned if we've come to this situation, this is a very common procedure for the way these get to this court. In that, plaintiff files the lawsuit, and the defense files a very skeletal motion to dismiss, saying, here's the two arbitration agreements, get us out of here. And then the real substance, the meat of the motion, it turns out to be our response, where we raise all these defenses and submit the declaration. And then typically, as happened here, the defense in their reply doesn't really address the facts. I mean, there's no dispute about my client's declaration, and there's no counter declaration. There's some cases out there, they're MDs, so I'm not going to talk about them, where counter affidavits have been brought in, which raise a question of fact under Matthews and Resga. But far more often than not, they just say, as they did here, it's voluntary. So that's the end of the story.
But
and
if that's the case, very quickly, because there's no controverting affidavit, is an evidentiary hearing really needed? Can't we simply read the affidavit and make the decision?
That's my point.
Okay.
And I would urge you to address that.
Yeah.
And there may be, it depends on the motion, of course. I mean, and the reply, sometimes they can raise the facts. They didn't here. And I don't think you can make I don't think we get there on the substantive unconscionability aspect, because under Harrington and the Clark case, there's three factors. And we discuss it in the declaration, but we don't address all three of those factors. But we also said, since we need to touch all three of these bases, we need evidentiary hearing and discovery on this issue, which was denied. So on the other three defenses, fiduciary duty, reasonable expectations, procedural unconscionability, I absolutely agree with you. Go ahead, Judge.
You make the argument that the statement in the arbitration agreement that an arbitration hearing will almost always resolve a dispute at less cost than a trial is a lie. Is that substantive or procedural?
That is substantive. Did I say lie?
No, that's my,
Oh, okay,
Well,
good,
you-
because
you say that's
I
a
said lie
false.
once
You
years
say
ago
it's
in
false.
court, and I always felt bad about it. Misrepresentation.
False.
Well, I think it is false. And it might be a lie, too, but I
Okay.
try not to use that connotation.
so that's procedural.
That's substantive
okay.
under
Sorry.
Harrington
Okay.
and procedural, and I'm telling you what you probably already know. Procedural has to do with the presentation. The content itself
Okay.
is a misrepresentation, and under Harrington and Clark. And that's why we, and that's all the last.
Argument, though, from the argument that under Clark, I can't afford it. This is, as I understand your argument, it's two parts. One is it's a false statement, and second,
You know what,
Because it's
Judge?
false, I can't
You
afford
are
it.
exactly right, and I answered your question erroneously. The fact that they misrepresented it and didn't tell the truth there, that is procedural. I apologize. I was thinking Clark,
And
and
I think that might be procedural.
yes, I apologize for that. You were exactly right. I'm glad you followed up on that.
Okay.
I've got 5 minutes left. I think I'm going to pocket them if I can here.
Okay. Thank you very much. Mr. Brown?
Morning. Bowen Brown on behalf of Life Care Centers of America. I'd like to start by addressing what Your Honor raised earlier. It is a difficult issue between the existence and the scope. I think clearly here plaintiff has conceded the existence of two arbitration agreements. And the arbitration agreement very clearly does say that the scope of those agreements should be determined by the arbitrators.
But have you conceded the non-existence of two agreements, and the ones your client asked to be signed that weren't?
There were two agreements. I think that we're assuming a lot of things here that aren't actually in evidence.
Okay, then let's.
And let me just say this.
Yeah.
All of these residencies were extremely short, 5 days, 6 days, 7 days.
Right.
So there's been an issue about, well, the arbitration agreement was signed after she'd already left.
That's not my concern so much. If anything, that that reduces the sort of aura of duress associated with them. But my concern is this: every time she stays, your client presents her with an arbitration agreement. 2 times she signs them, 2 times she doesn't. Is there any significance to that? Or do you present these arbitration agreements for the heck of it?
There is no significance in this regard, in the big picture. Honestly, what I think happened is the last 2 agreements came to her after her mom had left, shortly before she died. And so it was a matter of, why should I sign these? Not a I'm taking a principled stand against
Didn't
these.
sign them.
But she didn't sign it. But the arbitration agreement addresses that, because it says, and this is on page 2, it's the 4th paragraph, all claims based in whole or in part on the same incident, transaction, or related course or care of services provided by the facility to the resident shall be arbitrated in one proceeding. One proceeding. That means
you're not going to have an arbitration over bed sores versus an arbitration over medication versus an arbitration. It doesn't necessarily mean that every dispute you have concerning the rest of your life is covered by this one agreement. If it did, I guess I would ask, why doesn't your client just make it easy on itself? Why not do an agreement one time that says, from now on, any dispute that may arise between us is subject to arbitration? And give that arbitration agreement once and be done with it, rather than have an arbitration agreement that is limited to each stay and submitted to the patient or her representative each time.
the wisdom of my client in that regard is beyond my understanding.
I'm not
Judge.
questioning its wisdom, but the legal effect of offering a document every time suggests to me that there's some significance to it. The party's course of dealing has to matter, doesn't it?
I think that it does. I don't think we have the evidence as to what that course of dealing here is to address it.
Well,
but
we have undisputed that she signed to and rejected to.
We do. And I, just to back up a second, Judge, because I know plaintiff said, well, if she'd been there 30 years, are you telling me that the very first agreement that she signed would govern all 30 years? The answer is, they brought this on themselves. The complaint that they filed alleged negligence for the entire period, the entire year, all 4 residencies. That's why that one proceeding is critical, Judge, because had they said, you know what, she signed 2 arbitration agreements, we're not interested in those, we feel, as they have kind of hinted at, that most of the negligence occurred at the end of her residency or at the end of that year, and claimed those 2, then my argument becomes much, much weaker.
Well, okay, that's interesting. So if we were to hold that the second 2 arbitration agreements didn't exist, and anything that happened in those 2 stays is fair game for litigation in court, and they responded by simply lopping, and everything before that was arbitrable, and they lopped off all the conduct beforehand, would we have a resolution to this case? I don't want to conduct a settlement conference, but I want to make sure I'm understanding your argument.
The argument is, my argument is essentially that, but a little bit different. The fact that she signed those first 2 agreements requires, per the agreement, that any claims including any claims that include those first 2 residency periods and anything else, all has to be brought in that one proceeding. You have to arbitrate everything. And that governs the wrongful death issue as well.
Okay. No, and I understand that's an interesting point. But if they were to amend their complaint to drop those, would you have any claim
Drop
that
what?
to drop the
first
conduct relative to the first 2 stays? Would you have any remaining argument that the case is arbitrable?
I don't want to make any promises, Judge, but certainly I think that weakens our position substantially, considerably. The agreement provides that anything, including those, has to be brought in one proceeding, and if they knock those out, then we don't have any arbitration agreements that govern these last 2 residency periods.
Okay, so in that case, would you contend, let's assume hypothetically they did that, would you contend then that because there was an arbitration agreement number 1, that you still get to go to the arbitrator to see if the scope of arbitration agreement number 1 covered all time in the future?
I think for purposes of this hearing, Judge, I have to take that position, that absolutely the scope is going to be determined by the arbitrator. We do have in existence arbitration agreements, and they're going to govern.
Then let me give you well, go ahead.
It seems like to me that there's quite a bit of back and forth in the briefs about what stay and care in the arbitration agreement means and whether it's broad enough to encompass all stays. That's a question that is the question of whether negligence arising from future stays is arbitrable, right?
Yes.
And the agreement cedes to the arbitrator the power to decide questions of arbitrability, correct?
Yes.
But I don't see anywhere in the record, do I, that the defense has argued that question should be reserved to the arbitrator. And in fact, to the contrary, what I think I see in the record here and below is that the defense has, if not invited the court to decide that issue, has not objected to the court deciding that issue.
I don't believe that was argued at the trial court level, Judge.
And not here either.
I did initially make that argument. I am happy to make that argument.
Is it in your brief?
It's not in the brief, Judge.
What do you, turning to the wrongful death for a moment, to those claims, I think your brief was filed, as I understand it, before the DiCamacho case came out from our colleagues in Tucson. What's your argument to us as to why we should not follow DiCamacho and conclude that even if the arbitration agreements are present and in existence and enforceable, they still don't cover the wrongful death?
I have a twofold argument in that regard, Judge. First of all, I think that the conclusion, well, I'll make that argument later.
Okay.
I think that Your Honors can follow DiCamacho, because what DiCamacho says, and it's in footnote 5, is they say because we conclude that the plain language of the admission agreement does not bind the statutory beneficiaries as parties to the contract, we need not address the broader question of whether express language in the agreement purporting to bind the statutory heirs would have been valid and enforceable. And we have that here. Our agreement does
So,
purport to bind the heirs.
so this case is actually presenting to us the factual scenario that they noted in footnote 5.
The
was
one
not
they
before them.
the one they punted on is the one that we have here, Judge.
Okay.
And again, I go back to this. That's why this one proceeding language is so critical, because again, we have the arbitration agreements. This is a cause of action arising out of the based on the same incident, transaction, or related course of care and services. So it has to be arbitrated in one proceeding. And then just below that, it says, hey, it's the intention of everyone involved. We're going to bind the heirs, include the resident's intention to bind his heirs. So we have the express language that De Camacho wanted.
I wonder, though, whether you're reading that one procedure language a little too expansively. One procedure, again, seems to me to mean we're not going to bifurcate, trifurcate, and quadrifurcate arbitrations. We're going to have one proceeding. I'm not sure that it means we're going to have one proceeding. If you allege one fact relating to an arbitrable period and 1,000 facts relating to a non-arbitrable period, that one proceeding means those thousands of facts are suddenly within the scope of the first agreement. That would be there would be much easier ways to say that in the agreement.
I disagree, respectfully, and again, I think this is an issue that is in the plaintiff's control. If they want to avoid arbitratable areas, they avoid those areas governed by arbitrations. But in any event, what Your Honor may have raised, as far as the one proceeding language, is something that needs to be determined by an arbitrator. And I would certainly raise that issue at this point in time.
Okay, let me give you a shot then at the question I asked Mr. Babe in the beginning. We have this situation where there's one question, and it can properly, I think, very legitimately be called a question of existence of an arbitration agreement. It can also very legitimately be called a question of scope of an arbitration agreement because of the facts of this case. Right? Which controls? It would seem to me at one level that the existence of an agreement is primary, that the determination whether an agreement exists must come before you ask what the scope of an agreement is. But I'm not sure that that's a complete answer, or that you would even agree with me that far. So,
Judge, it is. I think Mr. Bain said the same, that it's a difficult question to answer because the scope can be subsumed within the existence.
Is there something wrong with having some overlapping here where it could be decided by either one, and whichever one gets to it first is the one that makes a binding decision?
There's nothing wrong with that, Judge.
We're there.
So here we
Obviously,
are.
at this point, we are pretty far down this road.
Yeah. So we're here. So if we determine that an agreement does or does not exist, would you consider that a legitimate and final resolution of the question? I mean, I'm not guaranteeing you a result either way. You may not like the result, but would the structure of having the court make the determination on the existence prong resolve the issue in a way that's legally appropriate?
I think if, and again, as Your Honor indicated, there is some overlap here. So certainly if Your Honors decide there is either an existing arbitration agreement or a non-existence of an arbitration agreement, I think that is your prerogative. It would be interesting if Your Honors split the baby and said that there were two arbitration agreements that existed and that has to go to arbitration, and then the arbitrators decided, well, our scope covers everything, and I don't know what would happen at that point in time.
Do you think we should hold that? You just laid out a possible holding. Do you endorse it?
No, it was purely an esoteric exercise. Honestly, I believe the language of the provision that there should be one proceeding. And the fact that we have any one agreement that, again, they put in their complaint means we have to have one proceeding. That's what the plain language of the agreement is, one proceeding.
Is that your main argument? Now I'm starting to, I think I understand. That's your argument for why claims arising from subsequent quick care is covered. It's not so much the stay in care provision. It's simply that only one arbitration needs to take place.
Yeah, and that's for practical purposes. Your Honor has said, well, no, they don't want to divvy it up and have one proceeding on pressure source. No, the facility doesn't want to have 20 different arbitration agreements. Doesn't want to have 20 different arbitrations. Doesn't want to have 20 different, litigations. All of these things. Everything is brought in one proceeding. I know that in my reply brief, I did make argument about the stay and how that term governs all the time at the facility. That's it's in the brief. I'm not arguing that. I'm not going to argue that here today. I mean, we made that argument. But the primary argument I'm making here is that this one proceeding language, which is clear, it is unambiguous, it indicates that all claims have to be brought if they arise out of this. Since a part of their complaint, well, I've already said that.
How unambiguous is it, though, if you and I understand it differently?
Well, then I would suggest that this is an issue that needs to be, as far as the scope, and it needs to be determined by the arbitrator, Judge.
All right. I mean, I'm not saying you're wrong. I'm just saying that there is that alternate reading of one proceeding, which is simply procedural and organizational. Once we get to arbitration, we're going to do it once.
Mm-hmm.
It doesn't really define the scope of what is arbitrable. It simply lays out the arbitration so that it happens in the cheapest way possible, which is an understandable desire on behalf of both parties.
I believe that the language that comes before one proceeding pretty much lumps everything arising out of it, and I think it kind of grabs everything and pulls it into its black hole vortex of this one proceeding. Everything goes along with that one proceeding.
Anything else? You have 3+ minutes. Might not work that way.
I just want to touch briefly on the issue of evidence. I know that there has been a proffer by the appellant, and we did raise in our brief the fact that there is no dispute that she signed the agreements. There is no dispute that she was given the opportunity to read them, that she was given the opportunity to ask questions, that she was not told they were required and were voluntary, and that she knew she was signing on behalf of her mom.
There is an issue as to whether she was given the explanation that the agreement says she was. Right? She claims in her uncontroverted affidavit that nobody sat down and explained this to her, even though the agreement specifically says, we sat down and explained this to you.
She did, in fact, sign it, and I know that now, after the fact, she's indicating she didn't read it. But she did sign the agreement, which...
Not an unknown phenomenon. But it's relatively rare to have an agreement that affirmatively recites that we've talked about this, and have that recital be false. And on this record, can we conclude that it's anything but false, given the absence of a controverting affidavit?
Well, you actually have the agreement itself, which says that they did talk about it. And we also have the fact that she signed it twice, Judge. She didn't just sign it one time, she signed this agreement twice.
Well, but on the other side of that coin, if we're going to start drawing inferences from those facts, we have the unusual fact that she refused to sign it twice. Once she... And this is going outside the record.
This goes outside, because I don't know that she refused it. We just have the fact that there is no signed version. She did not sign those two.
Right.
Yes,
and
sir.
she testifies. The only testimony, the agreement isn't testimony. The agreement is just what we're arguing about. The only testimony is that she never got that written explanation.
Well,
that oral explanation.
The agreement is evidence, and it's part of the record, and it does indicate that it was discussed with her. I understand there's no testimony in that regard, but there certainly is evidence that she did she did agree to it.
Why
She
not
did
then
say-
submit an affidavit saying, hey, everything in the agreement happens to be true, because here's the person who sat down with her?
I don't know why that wasn't done at the trial court level, Judge.
On another question. The question I asked Mr. Boehm earlier about the truth of the assertion in the arbitration agreement that arbitrations are almost always less expensive. What should we assume the truth of counsel's affidavit, as I understand it, that was submitted at the hearing? In his experience, that arbitrations of this matter cost significantly more than trials. What should we do with that assertion?
First of all, Your Honor, you can take judicial notice of the fact that there are a legion of cases that all say exactly what's in the arbitration agreement, and that is that arbitration is typically cheaper and faster than litigation. It is something that could be judicially noticed. So there is no plaintiff suggested there's some type of fraud in the inducement or something like that by putting it in the agreement. It's not. It actually comes out of cases, including Harrington. As far as Mr. Bain's suggestion, there is no evidence as to what, and it has to be specific evidence, about what the cost would be for this arbitration, and there is none. My time is up.
Thank you very much, Mr. Brown. We appreciate you've come a long ways to talk with us this morning. Thank you. Mr. Boehm came across town.
Yeah, I did, Judge. Came from home, actually. I've got just a handful of points here. Addressing the last one first about the absence of cost, specific cost relating to our client and the cost in this case. That's why, yeah, there's no evidence of that, but that's why we requested discovery and an evidentiary hearing on that, which is what both Harrington and Clark tell us to do. And the judge in this case just kind of poo-pooed that and just said, no, you're not going to get that. So that's the error. But I agree, there's no evidence, but we asked for an opportunity to get it. Second thing, there is a great dispute about whether she was fully informed and was properly advised of what arbitration entailed, because that's what we put in our affidavit. So his Mr. Brown's comment that that all of this stuff was undisputed is absolutely false. That's the whole point that you and I talked about 10 minutes ago about the lack of an affidavit disputing what we say happened. Judge Swan, you made a hypothetical about what if we dropped all those other claims, I guess it's the March and July ones. I don't think that would make any difference at all. I mean, the defense kind of made it sound like everything would go away there. The agreements are there. The agreements wouldn't go away. And if the agreements, just because we don't allege any claims on them, the agreement still exists. So they would have all their same arguments that they're making now.
Oh, but I think the concession that your case would have been a lot cleaner if you alleged facts beginning as of a time that, after the second stay.
Except
was a reasonable take on things, don't you?
No, and the reason I say that is because abuse and neglect occurred in March and in July, and that probably didn't result in the wrongful death.
So you agree
aspect
that you
of it.
might have to arbitrate those, and
Maybe.
not
I
others.
mean, that was one of my off-ramps contingencies.
then
I mean,
what do you
it's
do with-
possible
Then
that
what do
the
you
court.
do with the one proceeding like
That, well, I totally agree with you, and you may have been devil's advocate on that question, but it all that does is say that all claims that are arbitrable need to be arbitrated in one proceeding. It doesn't expand the scope of the arbitration, and I mean, he said it several times. He didn't tell you why it would expand. The scope of the arbitration is back on page 1, which Judge Johnson pointed out. All claims arising out of the resident's stay and care provided, and that gets back to whether that means all stays now and forever and ever, amen, or just these, which is our point. But if it's not an arbitrable claim, they can't bring that in with that one proceeding. But I totally agree with your question. I mean, we couldn't have, and it doesn't make expeditious sense to have multiple arbitrations on claims that are arbitrable. So if some claims, if you end up deciding that all this has to be arbitrated, wrongful death aside, yeah, it has to be done in one claim. But if, and Arizona law allows this, if some claims have to be arbitrated and some claims are not subject to arbitration, then they can proceed at the same time. I think it's the Forrest case I cited in my brief. I got 1:39 left to talk about D. Camacho. They're exactly right. That footnote. This is a little different, and this was, as you know, I filed a motion to publish whatever you decide in this case on that specific issue. Of course, we didn't know D. Camacho was coming out then, and the analysis that Division 2 did is very similar to what we went through here. The only difference is we have that language that says all errors are bound, and D. Camacho. I mean, I've never heard of that not being included. But it doesn't make any difference. I mean, yes, the court needs to address that. And we would request that you do it in a published opinion because, as you know, there's MDs out there that have addressed this. And this is, obviously, it comes up a lot. So we need marching orders, so to speak, for when this arises, inevitably, as it will, down the road. Just for your information, you may know this already, D. Camacho PR was filed by both sides. It's not on an agenda now. I don't think the Supremes are setting an agenda in either July or August, so it's going to be fall at best for that. I've got 30 seconds left. I'm going to let you forgive me.
We
for
need
listening.
that 30 seconds.
Yeah, sure.
All right.
Thank you
Mr.
very much,
Boehm.
Your Honor.
Thank you both. We appreciate your arguments, both in the briefs and orally. And thank you for helping us on this case. And we'll take the matter under advisement and issue a decision in due course. And we'll take a brief recess to allow the next case to come forward.